This video is without prejudice or without recourse. This is Diesel for We the People News, not attorney, not giving legal advice. This is a learning video. Do not take it otherwise. Okay? Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. Here we go. Part 2.
Between law and the Constitution must exist before the judiciary is justified holding the law unconstitutional. This principle is of course in line with the rule that doubts as the constitutionality should be resolved in favor of the constitutionality and the beneficiary. 16 AM JAR 2D, Sector 256. The general rule is that an unconstitutional statute, whether federal or state, though having the form and name of law as in reality no law, but is wholly void and ineffective for any purpose since unconstitutionality dates from the enactment and not merely from the date of the decision so braining it. An unconstitutional law in legal contemplation is as inoperative as if it never had been passed. Such a statute lives a question that is purports to settle just as it would be had the statute not ever been enacted. No repeal of an enactment is necessary, since an unconstitutional law is void. The general principles follows that it imposes no duty, confers no rights, creates no office, bestows no power of authority on anyone, affords no protection and justifies no acts performed under it. A contract which rests on an unconstitutional statute creates no obligation to be impaired by subsequent legislation. No one is bound to obey an unconstitutional law. No courts are bound to enforce it. Persons convicted and fined under a statute subsequently held unconstitutional may recover the fines paid. A void act cannot be legally inconsistent with a valid one, and an unconstitutional law cannot operate to supersede an existing valid law. Indeed, insofar as a statute runs counter to the fundamental law of the land, it is superseded thereby. Since an unconstitutional statute cannot repeal, or in any way affect an existing one, if a repealing statute is unconstitutional, the statute which it attempts to repeal remains in full force and effect, and where a statute in which it attempts to repeal remains in full force and effect, and where a clause repealing a prior law is inserted in the act, which act is unconstitutional and void, the provision of the repeal of the prior law will usually fall with it and will not be permitted to operate as repealing such prior law. The general principles stated above apply to the Constitution as well as the laws of the several states insofar as they are repugnant to the Constitution and laws of the United States. CONSTITUTIONLAW59. 16 AM JAR 2D, Sector 257. The actual existence of a statute prior to determination that it is unconstitutional is an operative fact and may have consequences which cannot justify being ignored. When a statute which has been in effect for some time is declared unconstitutional, questions of rights claimed to have become vested of status of prior determinations deemed to have finality and acted upon accordingly, and of public policy in the light of the nature, both of the statute and of its previous application, demand examination. It has been said that an all-inclusive statement of the principle of absolute retroactive inviolability cannot be justified. An unconstitutional statute is not necessarily a nullity. It may have indeterminate consequences binding on the people. 16 AM JAR 2D, Sector 258. On the other hand, it is clear that Congress cannot by authorization or ratification give the slightest effect to a state law or constitution which is in conflict with the Constitution of the United States. 16 AM JAR 2D, Sector 260. Although it is manifested that an unconstitutional provision in the statute is not cured because included in the same act with valid provisions, and that there is no degrees of constitutionality. Moodic v. Hen 3 19 U.S. 105 Satsmiley 1943. A state may not impose a charge for the enjoyment of a right granted by the federal Constitution, and that a flat license tax here involves restraints in advance the constitutional liberties of press and religion and inevitably tends to suppress their existence. That the ordinance is non-discriminatory and that it applies also to peddlers of wares and merchandise is immaterial. The liberties granted by the First Amendment are and in a preferred position. Since the privilege in question is guaranteed by the federal constitution and exist independently of the state's authority, the inquiry as to whether the state has given something for which it cannot ask a return is irrelevant. No state may convert any secured liberty into a privilege and issue a license and a fee for it. Shuttlesworth v. Birmingham, Alabama 373 U.S. 262 Sad Smiley 1962. If the state does convert your right into a privilege and issue a license and a fee for it, you can ignore the license and a fee and engage the right with impunity. United States v. Bishop 412 U.S. 346 sets the standard for criminal violation of willful intent. 1. It must be proven that you are the party. 2. It must be proven that you had the method or opportunity to do the thing. 3. It must be proven that you did this with a willful intent. Willfulness, an evil motive or intent to avoid a no duty or task under a law, with a moral certainty. Now, since the prosecutor does not have a cause of action for which relief can be granted, Your Honor, may it please the court, counsel is specifically precluded performing his major task. Therefore, Your Honor, may it please the court, at this time, I would motion most graciously for a dismissal, with, of prejudice, for failure to state a cause of action for which relief may be granted by this honorable court. CONSTITUTIONLLAW69. And I would like to collect my cost and fees for having to defend this frivolous complaint. Sir, may it please the court. Owen v. Independence 100 Volume Supreme Court Reports. 1398 Sad Smiley 1982. Maine v. Thibitot 100 Volume Supreme Court Reports. 2502 Sad Smiley 1982. The right of action created by statute relating to deprivation under color of law, of a right secured by the Constitution and the laws of the United States, and comes claims which are based solely on statutory violations of federal law and applied to the claim that claimants had been deprived of their rights, in some capacity, to which they were entitled. Officers of the court have no immunity when violating constitutional right from liability. When any public servant violates your rights, they do so at their own peril. Title 18 U.S. Code Sector 241 and Sector 242. If upon conviction, you are subject to a $10,000 fine, 10 years in jail, or both, and if theft results, life in prison. Title 42 U.S. Code Sector 1983, Sector 1985, and Sector 1986. Clearly establish the right to sue anyone who violates your constitutional rights. The Constitution guarantees, he who would unlawfully jeopardize your property loses property to you, and that's what justice is all about. Judge, you are deemed to know the law and are sworn to uphold it. You can hardly claim that you acted in good faith for willful deformation of a law, and you certainly cannot plead ignorance of the law, for that would make the law look stupid for a knowledgeable judge to claim ignorance of a law, when a citizen on the street cannot claim ignorance of the law. Therefore, there is no judicial immunity. Briers v. United States 273 U.S.R. 28. Constitutional provisions, where the security of a person and property are to be liberally construed, and it is the duty of the courts to be watchful for the constitutional rights of the citizen and against any stealth encroachment therein. When a federal officer participates officially with a state official in a search, so that in substance and effect, it is their joint operation, the legality of the search and the use in evidence of the things seized is to be tested in federal prosecutions as it would be if the undertaking were conclusively the federal agent. Boyd v. United States 116 U.S.R. 616. The court is to protect against encroachment of constitutionality or secured liberty. It is equivalent to a compulsory production of papers, to make the non-production of them a confession of the allegations which is pretended they will prove. The seizure of compensatory production of a man's private papers to be used in evidence against him is equivalent to compelling him to be a witness against himself, violation of the Fifth Amendment, and in a prosecution for a crime, penalty or forfeiture is equally within the prohibition of the Fifth Amendment. Miranda v. Arizona 384 U.S. 436. CONSTITUTIONOLLAW79. Where the Miranda warning the police gives at arrest comes from: refuse to say anything without a lawyer present. Do not ever sign a statement that you have been told of your rights. Keep your mouth shut. In the absence of other effective measures, the following procedures to safeguard the Fifth Amendment privileges must be observed. The person in custody must, prior to interrogation, be clearly informed that he has a right to remain silent and that anything he says will be used against him in a court of law. He must be clearly informed that he has a right to consult with a lawyer, to have a lawyer with him during interrogation, and that if he is indigent, a lawyer will be appointed to represent him. If the individual indicates prior to and during questioning that he wishes to remain silent, the interrogation must cease. If he states that he wants an attorney, the questioning must cease until an attorney is present. Where an interrogation is conducted without the presence of an attorney and a statement is taken, a heavy burden rests on the government to demonstrate that the defendant knowingly and intelligently waived his constitutional counsel right. Where the individual answers some questions during interrogation or cuts the interrogation, he has not waived his privilege and may invoke his right to remain silent thereafter. The warnings require that the waiver needed in the absence of a fully effective equivalent perquisites to the admission or admissibility of any statement, inculpability or exculpability made by the defendant. The limitations on the interrogation presses required for the protection of the individual's constitutional rights should not cause an undue interference the proper system of law enforcement as demonstrated by the procedures of the FBI and the safeguards afforded to other jurisdictions. In each of these cases, the statements were obtained under circumstances that did not meet constitutional standards for protection of the privilege against self-incrimination. Where rights secured by the Constitution are involved, there can be no rule or law-making or legislation which would abrogate or abolish them. Norton v. Shelby County 118 U.S.A. 425. An unconstitutional act is not law. It confers no rights, it imposes no duties, it affords no protections, it creates no office. It is in legal contemplation as inoperative as though it has never been passed. The court follows the decision of the highest court of the state, in construing the Constitution and the laws of the state unless they conflict with or impair the efficacy of some principle of the federal Constitution or of the federal statutes or rule of the commercial or general law. The decision of the state courts in questions relating to the existence of its subordinate tribunals and eligibility in elections or appointment of their officers and the passage of its laws are conclusive upon federal courts. While acts of de facto incumbent of an office lawfully created by law, and existing or often held to be binding from reasons of public policy, the acts of the person assuming to fill and perform the duties of an office, which does not exist, can have no validity whatever in law. U.S. v.s. Doherty 473 F2D 1113 at 1139. States, the jury has an unreviewable and unreversible power to acquit in disregard of the instructions on the law given by the trial judge. U.S. v.s. Moylan 417 F2D 1002 at 1006. States, we recognize, as appellants urge, the undisputed power of the jury to acquit, even if its verdict is contrary to the law as given by the judge. Texas Constitution Article 1 Section 19 states, no citizen of this state shall be deprived of life, liberty, property, privileges, or immunities, or in any manner disfranchised, except by the due course of the law of the land. CONSTITUTIONOLLAW89. Texas State Law on Larceny and Extortion Section 31.01, a. Creating or confirming by words or conduct a false impression of law or fact that is likely to affect the judgment of another in the transaction. Notice: information served herein is for educational purposes only. no liability assumed for use. The information you obtain in this presentation is not, nor is it intended to be, legal advice. Author does not consent to unlawful action. Author advocates and encourages one and all to adhere to, support and defend all law which is particularly applicable. If anything in this presentation is found to be in error, a good faith effort will be made to correct it in timely fashion upon notification. Void where prohibited by law.
I agree. All right. Always try to operate in good faith. This is the question that we have against attorneys and judges. They are not operating in good faith. They are bluntly deceiving you on purpose, design, especially administrative courts. Federal courts, you get more remedies, but in your town, they are fraud, 100%. Whether you go by legalese and hold the laws against them, there is remedy there to go after these judges. Common law, contract law, all these things can be held against them in administrative courts, magistrates. Okay? Because the county and the city are 100% lying and against you. Now, that being said, do these people know? No. Why? Because they was raised the same way you was. All right? They do not know. They just go to work one day, somebody showed them how to do something, and then they turn around and just followed orders without doing research. But since there's magistrate and judges, they should have known better. Because the law. The attorneys should know better. Because they, study the law. So, the ones who are really in trouble is the attorneys and judges. It's the reason why you file a judicial complaint or a criminal complaint on the judicial. Send it to the prosecutor, send it to the grand jury. Now, you're not going to get anywhere. But when he does not do that, then you file a bar grievance against that prosecutor, attorney as well. I just keep adding and adding. I mean, you would probably file a bunch of bar grievance on attorneys if you just follow the law. Really, there'd be a bunch of attorneys out there you'd be filing a grievance on because they, in fact, don't follow the law or facetious. And the judges and attorneys are kissing one another's butts. So you have to file a judicial complaint on the judge or criminal activity on the judge, as well as the officer of the court, officer in the court, whatever he's called. The particular states have different names. All right, but when you say arrest that judge, by gosh, if he's not doing it, now you file a criminal complaint on that deputy. All right? Because he did not keep the peace in that court. Just saying, y'all. We need to start filing these things in record and leaving paper trails for any claims you decide to put upon them. Remember, really, in all actuality, they do not have immunities. They just gave it to themselves unlawfully. These will be the People News. Bye, y'all.